Absolutely.
Good evening. How are you?
Very well, thank you.
Good, good. We got Ship here. I sent you a co speaker invitation. See if you get that. So we've got we've got King and Ship, which I guess together collectively you guys are Kip. That's what I'll say about that. And also tonight we are probably going to have the lovely and delightful Professor Margot Cleveland. She and I have been friends. We started out just as Twitter friends during the Kavanaugh confirmation hearings, and we've become sort of friends closer since then, doing various things. She was my client when we filed the amicus for General Flynn, and we follow one another, obviously, and we talk offline. So Margot is great, and she's been really covering closely the pleadings in this case that we're going to talk about tonight, which is this battle in Florida between President Trump, Jeff Clark to a certain extent, and also the two guys who are still live defendants in that case. Hey, here's Margot. Margot, I'm going to send you a co-host invite. Check that out. We have found that the audio works better if we've got two or three hosts. So hopefully that will come through to you. And so there've been a lot of procedural moves on this, including today, Sunday. So we're going to talk procedure, which I know you guys love. Margot and I certainly love it, don't we, Margot? We love procedure. You got to unmute yourself, hon. There.
Right. I also love direction because I'm not so good at some of the tech stuff, but I am in and I'm looking forward to hearing what the gang all has to say.
Yeah, because I think we're pretty much on the same page on this one.
I think so.
Yeah, but it's just fascinating the various developments. There's Ship. Hey, Ship, can you hear us?
I can.
Fantastic. We got Margot and King too. All right, so the whole band is back together. I have Steve here beside me. He may or may not chime in. He is, I don't know if folks know this or not, but he's an appellate, an administrative law expert. He's been doing administrative law for 50 years. And so he may chime in on some of the issues because they're going to come up in this case. So we'll see. He's sitting here. Sometimes he doesn't say anything, he just listens. All right. So where should we start? Let's start. I made notes of the timeline because this case has just been bouncing back and forth between these two courts pretty much since the 6th. Today is the 12th, so not quite a week here. So what happened first was the two defendants who are co-defendants of Trump's in the Mar-a-Lago case. Now remember, Trump has been dismissed out of that case. The government dismissed because Judge Cannon ruled that Jack Smith was unconstitutionally appointed, and then Trump won the election. And per the Department of Justice guidance, a sitting president cannot be prosecuted. And so the special counsel has been disbanded, basically, and they dismissed that case, which was up on appeal from Judge Cannon's ruling. So they dismissed Trump out of the appeal, but not the other two defendants, who are, Ship, you know this case, I think, better on a personal human level than we do. This defendant, does he pronounce his last name Nauta? Do you know? You got to unmute yourself. There you go.
Nauda. I think it's Ralph Nauda.
Nauta. And the other defendant's last name is De Oliveira?
Yeah, I think that's a Cuban name. I'm not exactly sure how. Nauda is Filipino.
Okay. All right. So those two guys are still in the case. The government still wants to prosecute them. And so I'm going to call them the co-defendants instead of trying to mispronounce and butcher their names all night long. So that's what we're going to call them. So they and their lawyers moved on the 6th in Judge Cannon's courtroom first for an injunction for her to bar the government from releasing Jack Smith's report, because behind the scenes they'd been talking to the Department of Justice about when the report was going to come out. Obviously, that was going to happen sometime between now and when Trump takes office on the 20th. And So they knew that that was coming up. So on the 6th, the defendants hauled off and they filed this emergency motion in front of Judge Cannon to bar release of the report. And the next day, the government filed a notice, not really a response to this motion. They called it a notice. And they told Judge Cannon that they didn't even really have the report yet because the special counsel was still working on it that day on the 7th. But they did expect to get it by basically close of business on the 7th. They were not planning to release it before January 10th. So they didn't either join in or oppose the motion. They just said, blah, 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 Cannon, here's some facts you need to know. And then she ruled. She issued her order that same day saying that she was temporarily barring the release of the report publicly. On that same day, in the 11th Circuit, the co-defendants also moved for an order, an injunction from the circuit court to bar release of the report. So let me ask you guys this, all three of you. Does it seem like the defense lawyers weren't sure which court had jurisdiction over this issue at the beginning here?
I think, and this is Margot, I think that they believed that they had a strong basis for jurisdiction in the district court, but they were not about to chance it and accordingly filed as well in the 11th Circuit. So I don't think it's so much that they didn't know what the court would think. I think
Right.
they had, I think, and if you read their appellate brief for why, or I'm sorry, I'm not sure if it was the appellate or the district court, but if you read the brief, they make a strong argument that the district court still has jurisdiction to basically enforce its orders, and that's their basis for why Canon should still be able to have it. But in their response that they filed after the 11th Circuit, they did mention that out of abundance of caution, that's why they filed in both courts.
Right. So they filed in her court on the 6th and in the appellate court on the 7th. Kingship, either one of you want to weigh in on that?
Yeah,
Go ahead.
I think the most confusion comes from Judge Cannon's order.
Yeah, I agree. So we're going to get right to that. But tell me first, do you think they were unclear about who had jurisdiction? Who do you think had jurisdiction?
I think the district court had jurisdiction.
I do too. Ship, are you in agreement with that?
Yes.
Yeah.
I think, yeah, there's certain, because she had dismissed on a legal ground that could turn around and come back if she's wrong. I think she has an obligation and the authority to preserve any due process rights considerations that might exist if the case comes back to her.
Right. Now, people are going to be like, well, but Leslie, all last week you told us Judge Marchand didn't have jurisdiction of that case once Trump's lawyers filed a notice of appeal up in New York. And so that it's all the same. Let me explain. So the rule is once an order or a final judgment has been appealed, jurisdiction moves from the district court, the trial court, to the appellate court. In the federal courts, that's the circuit court. But jurisdiction moves for the issue that was appealed on. Now, if that's an interlocutory order, that's all that goes up, unless it's the kind of interlocutory appeal that prevents the rest of the case from going on, which some interlocutory orders do and some don't. So I'll give you an example. In New York, Trump filed an interlocutory appeal in Judge Marchand's case on the gag order. And that did not deprive Marchand of jurisdiction over the entire case while that appeal was going on. But the immunity, because it's the kind of issue that says, I'm entitled not to be put on trial at all, the courts have previously said in other contexts that that's the kind of thing that stops the whole case dead in its tracks. That's for interlocutory orders. In Judge Cannon's case, her order of dismissal is a final order of the case. She's saying this case doesn't belong in my courthouse. Thank you very much. Goodbye. So in that situation, the whole case, of course, moves up to the Court of Appeals. But as Ship has just said, because there's a possibility the case would come back, the district court, the trial court, retains jurisdiction over what lawyers would call ancillary matters, right? So these two defendants are still on, presumably on some kind of release while their case is up on appeal. So if one of them violates their release order, commits another crime or, does some other kind of stuff, the government can still haul him in front of Judge Cannon and say, you should punish him because he's violating his release. So things that aren't sort of the meat of what the case is about still rest with the district court. So I think, as I was saying all last week, once the government appealed Judge Cannon's order to the circuit, the case moved to the circuit, but the district court retained jurisdiction over ancillary matters. This seems to me clearly an ancillary matter. So I think she had jurisdiction. She seemed to think she had jurisdiction, but then we arrive at King's Point because what she ordered was she granted the injunction to bar the government from releasing the Smith report. But what she said was she barred it for as long as the request for injunctive relief in the 11th Circuit was pending, plus 3 days. So, and as I said, she did that without even getting a response from the government because I think she interpreted this notice that they filed as their response. And I want you guys to remember that because I want to ask you guys all about this practice that the government is engaging in of filing these notices. And that kind of muddied up the waters about where the case stood. So, King, that was your point. What were you going to say about it?
It's written as a preserve the status quo order until the 11th Circuit does something. She, in other words, she didn't address the merits of the motion at all. She just said, let's keep
Freeze.
freeze everything, and I'm going to kick it to the 11th Circuit, and they're going to have the final say
Right.
because it's in front of them right now.
Right.
That's the way she was thinking,
Which
which
is kind of
is
unusual. Usually an injunction says, all right, I bar this, and then you can appeal that. But here she put a time deadline on it, which is really creating problems now.
it is because the 11th Circuit denied the injunction, but almost in the same breath, said, go back to the district
Go back and
court.
talk to her. Right. Yeah. Right. Okay, so let
So
me follow with the timeline here. All right, so on the 7th, the government files this crazy notice. The defense lawyers for Donald Trump move also on the 7th in Judge Cannon's courtroom to intervene in the case because he's been dismissed out of that case. Cannon rules. The government files a second notice that says, well, we're still preserving our right to respond to this thing in your courtroom, Judge Cannon, but we're going to litigate it in the circuit absent direction from you that you want us to respond. Basically, since you ruled, we're going to go talk to the circuit. So that was the 7th. Meanwhile, in the circuit court on the 7th, the defense then files a notice with the Court of Appeals telling them what Judge Cannon did. And this is a technical question, Margot, I wanted to ask you. Interestingly, also on the 11th Circuit's docket, there's a notation that shows the district court order. And I don't do a ton of appellate work. I do some, but not a ton. And so that looks like that's an order that was almost like a notice or electronic notice from the clerk's office that, hey, the district court ruled on this. Have you seen that before? Can you explain that?
I'm wondering if that was merely Judge Cannon had said that you need to notify, or you're talking it was in front of the 11th. I'm
Yep.
not sure. I'm going to pull that up real quick and take a look at it.
It doesn't
But
seem to be a filing by one of the parties. It's like it looks like it's from the clerk. It says U.S. District Court order. And evidently, the defense lawyers, while you're pulling up, I'm going to keep going here. Evidently, the defense lawyers didn't know that was going to show up on the docket either because they filed a supplement with the circuit on the 7th, notifying them of Cannon's order, so they would know what was going on. And but then also that additional entry was there, which I was puzzled by. So on the 8th, the next day, the government responded in the circuit and said, you shouldn't do this. Um, and the defense then filed another notice saying that they wanted until the next day to respond in the circuit. And the circuit court said, no, you need to respond today by 5. So defense filed their reply by 5 p.m. on the 8th. And President Trump also moved to file an amicus in the 11th Circuit that same day. Then the next day, on the 9th, the court granted his amicus and denied the order, as King was just telling us. Okay. Margot, did you see that entry on the docket?
I did. I'm not sure what that is. I'm inclined to say one of the parties just filed that to notify the court. Either Trump's attorney, I'm sorry, not Trump's attorney, one of the two defendants. It could have been that the clerk does it as well. So I don't have anything to really
Yeah.
enlighten on that.
Yeah, it's like an appellate little technical rule maybe. It doesn't seem like it has a notation on there of which that a lawyer filed it. So I'll look at that again. But setting that aside. All right. So on the 8th, the circuit says, we're not granting this. And oh, by the way, government, you can appeal Cannon's order. Oh, okay. Right? But her order, as King was explaining, basically says we're just freezing everything until the circuit rules plus 3 more days. So does that mean that do we think that means that the circuit thought Judge Cannon had jurisdiction or not?
You can read it that way.
Yeah, but not necessarily, right?
Right.
Yeah,
And I think the key is that the circuit didn't say she doesn't have jurisdiction.
right,
And that is exactly what the Department of Justice wanted the 11th Circuit to do,
right,
and what the DOJ asked the 11th Circuit basically to do, and that it refused to do. And as you will come in in your timeline shortly to note that they filed that ridiculous notice,
yeah,
basically as it, and I need to just riff on this for a second
go
because
ahead.
it was so inappropriate.
Right,
The way it works is when a circuit court issues a decision, or in this case, an order, if you think they screwed up, you file a petition for rehearing.
right.
There's a procedure to do this.
There's a rule, tells you how to
There,
do it.
exactly. And instead, what the DOJ did was filed a notice saying, we filed a notice of appeal like you told us, but you guys screwed up. You need to fix it and
we
say that she
renew we
can't do
renew
it.
our request, they say.
Right.
What?
Exactly. You can't do that.
No, you
I
can't.
mean, obviously it's the Biden administration and they can do whatever they want to do, but that's not how it works.
They're freaking out, don't you think, from their
That,
pleadings?
oh, yeah, they're completely freaking out, which is going back to one of the things after this came out. I had tweeted that it was a victory for Trump, while everybody else was saying it was a loss for Trump. And I had to kind of walk that back because it wasn't like a victory at the end of the day, but it was a huge victory because it meant Cannon was still in the game and she could still enter a longer injunction because the 11th Circuit didn't say she lacked jurisdiction.
Right. They just said, hey, government, you can appeal her order if you want to. Don't come to
Exactly.
us directly. So, which doesn't preclude them from saying in their argument that she didn't have jurisdiction, but the circuit doesn't really say. So it looked to me like, and the defense lawyers definitely interpreted it this way, that the circuit was trying to straighten out the what the defense lawyers call regular order, right? Like there's a way to do this, and this isn't it. So let's go, do it the proper way up through the district court. So just so people are clear on the timeline. So on the 9th, the Court of Appeals granted President Trump's amicus to come in. Jeff Clark filed an amicus that same day, and the court denied the defense lawyer's request for an injunction, but they pointed out in their order that the government could appeal from Judge Cannon's order granting the injunction. That happened on the 9th. Okay, so after the Court of Appeals pointed that out to them, the government filed a notice of appeal in the district court. That's where you file your notice of appeal, right? You file a one-pager that says, I appeal from whatever order or from the judgment. Then the clerk's office, we've talked about this many times, does all the magic that the clerk has to do to move the case from the district court to the Court of Appeals. So, but in addition to filing just the regular old notice of appeal in the district court, the government filed in the appellate court a quote-unquote notice with the 11th Circuit saying, hey, we did what you told us to. This is what Margot was talking about. We appealed Judge Cannon's order, and we also think that you should reconsider what you just said. In denying our request for injunctive relief in this court, because, reasons.
If I can jump in for a second, I thought
Go ahead,
Margaret was
Chip.
going to say. What my thought was here when she pointed out how they evaded the rule for seeking either rehearing or rehearing en banc. When I looked at that, I thought, oh, okay, so a notice, and I've been writing a Substack about this off and on today. So they filed a notice of appeal. And as you correctly pointed out, that's actually a notice to the district court that,
Right.
oh, by the way, we are taking your order up to the appellate court, and then the district court sends the necessary information up to the appellate court to open a case there. You don't file your notice of appeal in the appellate court, even though a lot of people make that mistake.
Right. Now, technically, they didn't do that. What their thing is called is notice of filing of
No,
notice of appeal.
that's my point. So they filed a notice of appeal, then they filed a notice of appeal.
Yeah, exactly. Yeah, that's what they called it in the 11th Circuit.
But the
That's a
reason they did
nothing.
it, is because the very next morning they filed the emergency motion
Yeah,
for summary reversal.
right. In the meantime, though, this is why it was flying thick and fast. So on the 10th, right, they filed their notice of a notice. Then the defendants that same day moved to strike that pleading, right? They made Margot's arguments, and they made some other arguments saying,
It was all that night. This all
yeah,
happened on the 10th.
right, on the 10th, right, that's what I
And
said, same
I
day.
think Stanley filed their motion to strike like at 11:30 p.m.
Right, exactly. Saying what Margot was saying, you can't do it that way. This is not how this works. So the next morning, the government filed a motion to consolidate both cases because, of course, the Court of Appeals clerk assigned a new number to it because it's a different appeal. They shouldn't have even been filing anything under that case number anyway, because their appeal, of course, generated a new number. So they filed a motion to consolidate that and for summary reversal. I want to ask you guys about that in a minute. Okay, that they filed on the 11th. That was yesterday, Saturday. So while all of that was going on the 10th, the government also had to respond to something that Todd Blanche and the other lawyers filed back in Judge Cannon's courtroom. So on the 9th, all three defendants filed a notice to Judge Cannon, basically because, notwithstanding her order, Merrick Garland sent a letter to the Congress saying basically that he was going to be sending them Smith's report. So the defense lawyers filed this, what they're calling a notice, to Judge Cannon saying that this was a violation of her order. And the next day, the government filed a, quote, counter notice, basically saying, no, we're not violating her order. Okay. And then the defendants also filed a motion for a further stay with Judge Cannon, because by the 10th, the circuit had said, we're not going to enter an injunction. And the government had appealed her injunction, which was going to expire 3 days after the circuit ruled. The circuit ruled on, let me flip my page over here. The circuit ruled on the 9th. So you don't count that day when you count the 3 days. So Cannon's order is going to expire tomorrow, Everybody seems to agree about that, but that's the only thing they agree on. But what do you guys make of this litigation by way of notice? The defense lawyers didn't file a motion with Cannon for, motion for show cause why the government's not in violation of her order. They just filed this thing called a notice that they give the judge facts on, and then the government files a counter notice back saying, nah, 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 no, we didn't violate the order. Your order says X, and all we told the Congress was XYZ. What do you guys make of this?
The only notice that really um, affects how this thing goes forward is the notice of appeal,
Correct.
and they did that
Right.
like within hours
Right.
of the 11th Circuit ruling, telling them you need to take an appeal of Judge Cannon's order. So before the ink was dry on that order, they filed a notice of appeal. And they did that for a reason. They knew that the defendants would be back before Judge Cannon
Right.
asking her to remove that uh, uh, caveat about when
Right. Her deadline that she
her
put on.
deadline, when it expires, and extend it for a longer period of time so she can decide on the merits whether the injunction should issue.
Right.
They didn't want Judge Cannon to hear that, so they filed an immediate notice of appeal.
They, the government.
They, the government, which technically takes it out of Judge Cannon's hands again,
Again, so we're gonna get to that. But
and
but but
and
back but back
and
up
and
for a minute
and,
with me.
and they can sit back at that point and watch the original injunction die.
Expire. Right. Okay. But tell me what you think about this. We're filing these notices with the court. Because where I practice, if you had tried to do that, I think the judges would say, if you want me to give you relief, then file a motion. I don't know what this notice is that you tell me XYZ facts, so the Attorney General's violating my order, but you're not asking for anything. Or if you are asking for something, then this is not a notice, this is a motion.
Yeah, it was all silly. And
But I'm not sure it's even proper under the rules. Margot, Ship, what do you guys think?
So at the district court level, I think it was more of a brushback pitch saying
Mm,
to DOJ, watch it, and that I don't see it was improper under the rules. What the DOJ did with their notice of a notice, where
mm.
they actually asked the court something on appeal, I think that was completely inappropriate.
Oh, I agree. You've
And
nailed that. That
and
is not a notice. That's a motion for rehearing, an
right.
improper one. Right.
And in addition, I would just say how ridiculous it is that they on I think it was 12:30 a.m. on Saturday, the government filed a emergency appeal on an order that is ending on Monday.
Yeah, I know. Right.
And as you noted, they did that for a reason. They wanted to take the jurisdiction away from Cannon.
Right.
But they can't do that because even if they're taking the jurisdiction on this order away from Cannon, there's a separate request motion that came that is saying, we want you to rule on our original motion that you never ruled on, because she didn't. She ruled 3 days to basically let them to hold everything because she wanted to let the 11th Circuit deal with it.
Right. She wanted
And
to defer to the circuit and not step on
right.
their toes.
And I actually think that what she was doing was prudent, because if you read how she framed it, she gave the 3 days not so that they could take the appeal and then maybe appeal it to the Supreme Court. She said, in order to allow there to be, I can't remember her language, but like some semblance of structure to how this happens so that we can have time to decide how this moves. And that 3 days is now allowing her on Monday to have time to decide whether
Right.
or not she's going to order further briefing or now what she's going to do with Jeff Clark's filing.
Right. Because we have said here, Clark filed a motion for to be an amicus in the circuit. Now, you've reported that he also filed a motion to file an amicus filing in the district court. Now, that doesn't show up on the docket yet. The reason for that, folks, is because you need leave to do that in the district court in a kind of a different way than you do in the appellate court, because it's more unusual that people file amicus briefs in the district court. So we know, right, Margot, you talked to the lawyer. They did file it, but they're waiting for the judge slash clerk to authorize that filing. And then at that point, it should show up on the docket, right?
That
I have a question real quick.
sure.
Let her answer that one first. Isn't that right, Margot? We'll see that eventually.
Yes, you should see that eventually. And I have gotten confirmation that the attorneys have, or the attorney has gotten confirmation that it has been received by the clerk.
Okay.
So they know it went through and it will go on the docket once the clerk puts it there. But the district courts do that so that people can't just throw in crazy stuff. And I can't remember one of the other Trump related cases. It wasn't limited, and you were seeing this flurry of
Oh my God.
amicus briefs
Right. Yes.
that
All over
hit
the
the
place.
docket.
Yeah.
So, but Ship, go ahead. What was
Yeah. What
your
was your question, Ship?
Yeah, it was back on the Jeff Clark thing before we jumped to the Jeff Clark thing. Has somebody confirmed yet that the Justice Department is closing its doors and will no longer be existence on the 21st? Is
Right.
that why? Is that why
I mean,
there's
that's the
all
emergency, right?
the emergency
Yeah.
is the Justice Department is going away,
Mm-hmm.
and
Maybe they
there
were
will
in
be
the Palisades neighborhood. They're,
there will be nobody there on the 21st to deal with any of this.
I mean, it has to be right, right? Because, there's definitely an emergency. No one seems to know what it is. But, the government just says stuff like that, and the courts are supposed to say, oh, sure, that makes total sense. And unfortunately, most time they do.
Well,
Okay.
can I say what happens on the 21st?
Sure, you sure. Go ahead, King.
Well, there's a new sheriff in town
Yeah,
on the 21st.
right.
And if his lawyers who are heading to the DOJ, once approved by the Senate,
Which is these same lawyers who are
these
filing these
same lawyers,
pleadings.
if they believe in the papers they filed to get Smith tossed because he wasn't approved by the Senate, and his the money he was paid to run this case wasn't approved by the Congress. If they believe in what they wrote, this case isn't going anywhere.
Right.
They will notify the 11th Circuit. We withdraw the appeal. And if it's still up in the air as to what happens to Smith's now unlawful report, they're going to announce that it's heading for the dumpster.
The circular file, as we used to say. Right. Okay. So to
It's going.
wrap.
It and all copies are heading for a shredder.
Right. Something. Okay. So let's finish off the procedure, and then we're going to talk more meat on the bone about really some of these issues. Okay. So we're up to the 11th. Okay, so this is the pleading Margaret was talking about. On the 11th, which was Saturday, yesterday, the government filed a motion to consolidate the two appeals and also for summary reversal. And I'm going to have Margot explain what summary reversal is as our appellate expert in a second. And then also on that same day, actually the day before, on the 10th, the defendants filed a motion with Judge Cannon asking for a further stay. And they technically asked for her to clarify kind of that her order was going to extend because more stuff is now happening in the circuit. And she put that order on to let the circuit proceedings play out. They want her to clarify that that order is in continuing effect, or they want her to issue another order extending the stay. And the government opposed that on the 11th yesterday. And then Judge Cannon put what we call a EC, electronic communication, um, or a minute order is what they called it in the courts where I practiced. Um, Ship, didn't we discuss this before? You call it electronic communication out in California, right?
Well, it kind of ever since we went to sort of ECF and electronic dockets, we just generally refer to them as ECs,
Right.
which is just an electronic entry. But traditionally, they've always just been called minute orders, which is an order issued by the court that's not in a separate document, but just noted in the document as a
Shows up on
docket
the
of the
docket.
case by the
Yeah.
clerk's office.
So in Florida, this thing is called apparently a paperless order. Okay. So Judge Cannon issued this
I, I,
paperless
I,
order.
I still am waiting for an explanation for somebody why the Southern District of New York does everything by letter.
Right. Well, that's why I'm wondering if we're getting all these notices, because isn't Blanche a New York lawyer? Um, so Judge Cannon issued yesterday an electronic order basically telling the government, all right, you've told us that this Smith report is in 2 volumes, and volume 1 deals with the January 6th case in New York, and volume 2 deals with this classified documents and obstruction of justice case about Mar-a-Lago here in Florida, and that there's no cross references between the two. But the defense lawyers were raising issues about whether that was true or not. So Judge Cannon issued this very interesting order basically saying, government, you need to confirm to me that there isn't any crossover between these cross references. And if there is, and she gave them a very broad definition of that and told them to liberally apply it, then you need to file something with me that shows me what the cross linkage is. Um, she issued that yesterday and gave them until today to file that, and they filed that this morning. They gave her a response. They filed 2 things. One's public, one's under seal. They claim that there basically were only 2 references to volume 2, the Mar-a-Lago part, in volume 1, the January 6th DC part, that are more like referring to the fact that there is the other case, no real meat or substance. And then they gave her a sealed pleading on that. But that's the latest and greatest. Nothing else has happened uh, from Judge Cannon as of this evening, since this morning. And the defense is going to have time to respond to the motion for summary reversal that the government is seeking in the circuit. So, Margot, explain to the folks, what is a summary reversal?
Sure. So I'm going to start with at the Seventh Circuit, which was the circuit I practiced in. I had never in 25 years heard of a summary reversal. And I was actually kind of surprised when I saw that because I actually do some pro bono stuff in Michigan. And I actually had requested a summary reversal on a case where the lower court was blatantly wrong. And it still took like 3 months before the court ruled on my request for a summary reversal.
Right. Makes it
So,
sound like it's going to be fast, but it's not.
right, it
But it is
wasn't. So,
shorter than the normal briefing.
right. So
Yeah.
I've heard of expedited briefing where you ask for
Yeah,
the
that's a
court to
different
get
thing. Yeah.
right. But maybe you all are familiar with other circuits having it, or maybe
Yeah.
it's just something because
Yeah.
we also have what are called staff attorneys. Staff attorneys work for the entire court, and I was a law clerk as opposed to a staff attorney. So it could be that there were summary reversals that we just never saw because
Mm.
those types of cases were usually there
Handled
was nothing
differently.
to them, so they
Yeah.
would go to the staff attorneys. So I would love to know if there's
Yeah.
something at the appellate level in the federal courts that allows for that.
Right. So let me go first and then we'll ask King and Ship. So where I practiced, which was Maryland, DC, and Virginia. Maryland and Virginia are both in the Fourth Circuit. DC has its own circuit. And so you could do them in the Fourth Circuit, but where I would see them a lot was in the DC circuit. And that circuit would use them to call basically cases that they don't like, that they don't want to, want one for one reason or another, um, off their docket. So it's pretty commonly used in DC. King, Ship, what's your experience with this? Because we all practice in different parts of the country. King, you want to go first?
I will, but in 50 years of practice, uh, in the Fifth Circuit, but in a couple other circuits too, I never saw one.
Right. Isn't it strange how it's a uniform system, except
Mhm.
it's totally not? Ship, what about the West Coast? Would you see these out there?
Never one time in 20 plus years in the Ninth Circuit did I ever see a request for a summary reversal, and just the concept strikes me as not as beyond odd, because
Yeah.
basically what you're telling the appeals court is disregard the substantive or procedural rights of my opponent and just do what I want.
Right. It's like, this is an easy case, Judge. So just rule quickly on it for me. You can also do motion for summary affirmance, I will add. If you are the other side and you want to say this case is beneath the dignity of the circuit to spend any time on, I win. So let's do it quick. So
Well,
that's what it is.
just pause a minute. To me, filing such a thing is really a slap in the face of the judges, because the courts I practiced in, if they thought what you just said about somebody's attempt to get relief from that, they had no hesitance in doing it on their own, uh, and said, this is ridiculous, dismissed, go away. We don't have time for this. Uh, and you don't have to ask for it.
You know who asks for it the most up here? Take a wild guess, you guys.
The government.
The government, exactly. It's almost always the government. Now, I've seen civil litigators use it too, but it's often the government, and that's why the court in D.C. especially goes along with it.
Well, and I mean, you can sort of the unique nature of the DC caseload, particularly involving the federal government. You're going to see a lot of crackpot filings,
Yep.
both in district court and the appellate court, more so than probably any place else,
Right. I agree.
because of the nature of the defendant, um, or the nature of the plaintiff challenging the government as the defendant.
Right.
But I agree with King in the sense that filing something like that, I think, should draw a response from a judge saying, "So you want to do your job and my job?"
Well, I mean, they're going to let the other side respond. It's just you don't go through all of the normal briefing procedures.
I don't think they had any intention of wanting to let the other side respond here.
Well, that's not how the
They're
procedure works. The other side
well,
has a right to
I,
respond.
yes, but they're racing the clock here.
Well, that's really what's going on, right? It's like an emergency appeal. Is what they're really
Right.
trying
But
to
it's not
do.
an it's not an emergency is not enough.
Now we're back to your
It's an
point. Are they going to
emergency
go poof at
motion.
the end of the week? Right.
Yeah,
Yeah.
it's an emergency motion for summary reversal, and not just an emergency. And it's
Right.
not just summary reversal. It's an emergency
Emergency.
motion for summary reversal
Right. Exactly.
with an expedited briefing schedule.
Right. Exactly. Oh my.
It's
Okay.
it's just crazy.
Yeah, it is. That's what I was saying. You can tell from their pleadings, they are really, uh, Margot nicely used emojis for this instead of the words, but they are acting like fucking batshit crazy, right? Over this whole thing that they cannot get their minds around the fact that this judge has told them they cannot release this report.
Oh, and let's get the players straight. You can't tell the players without a program.
Right,
Jack Smith resigned,
right.
so
He's
this is
gone
not
as of
Jack Smith.
Friday. Yeah,
This is the civil division lawyers at the DOJ.
right.
Yeah, it's the program. I noticed that today when I saw the facts. Like, oh, this is the programs branch now.
Yeah.
Where the hell did the programs branch come from?
I don't know.
Are they the special counsel program? Are they
Right. I know.
representing the
I
special
know.
counsel
It's a
program?
euphemism, right? Because didn't Garland assign this to the U.S. Attorney for the Southern District of Florida?
And I think the U.S. Attorney for the Southern District of Florida responded first. I think the problem has arisen that Jack Smith has resigned, so there is technically no longer a special counsel's office,
Right.
which only adds to the consternation of canon that didn't I tell you that you're not a proper federal
Right.
official?
Right. You're not a thing. Right. Oh my God. Okay. So, all right. So they've appealed this, the government, and they've got their, goddamn hurry it up emergency motion for summary quickety quick reversal on file with the circuit. Meanwhile, the defense lawyers, as I said, the next day they want a further stay, or the same day, they want a further stay from Cannon. The government's opposing that. The defense lawyers have not filed their reply yet. I don't know if they're going to. And Cannon hasn't ruled on it yet. But here's the interesting thing. We're back to the same argument again that we were talking about in the New York case, because the government is opposing the motion for additional stay, saying that Cannon doesn't have jurisdiction to extend her order because once they filed their notice of appeal, the jurisdiction zoomed out of her courtroom and ran up to the 11th Circuit. And so they're saying, she cannot clarify, modify, extend. And that is what the law is. That's why I was yelling at, on Spaces all last week. Once you file your notice of appeal, that's it. But that doesn't mean that she can't issue a new order, right? And so, Margot, you've read these pleadings, I think, more closely than I have. The defendants can they can file a new motion and ask for a new order for sure, right? But I was intrigued by your point that she never kind of ruled on their original motion to begin with.
Right. And that's one of the parts that I think was confusing
Yeah.
because the defendants filed tandem motions. They filed basically the exact same motion for an injunction before Cannon and before the 11th Circuit. I think a lot of people assumed that they only asked the district court to stay it until the 11th Circuit ruled, and they didn't.
Right.
They asked for an outright injunction to bar the release at all. And Cannon was very cautious. And what she did instead was say, well, I'm going to prevent them to rule or to issue it for 3 days so that we can have time to figure things out. And that will end when the 11th Circuit is done. So I actually don't think that she really ruled on that motion. She
I
entered
don't
an
either.
order.
She entered a
rel-
different order, which I think
Right,
was based in part on this notice that the government gave her, explaining factually that they didn't even have the report yet. The day that she ruled on it, they didn't even have the report yet.
right. And the other part that you have to keep in mind is even if that's true, that she ruled on it, she made clear in her order yesterday that still pending before her is Trump's motion to intervene.
Right.
And all she has to do is grant that and then enter a new injunction.
Right.
Although I need to ask you guys, my understanding is that you cannot intervene in a criminal case.
Right. I don't think you can either. Chip, I was going to ask you that. What do you think? Procedurally, I do not think you can and intervene.
That's correct, but that's why Jeff Clark is saying I'll file a civil case in 4 days if necessary.
Right.
That's
Now,
that's
the
exactly why they're doing that.
the
Now Trump could do
president's
the same
motion
thing.
says intervene or act as amicus. She can certainly accept him as an amicus, but as an amicus, you can't ask for specific relief.
Right. And that again tees up why the Clark filing was so huge because it is joining in Trump's motion to intervene. But I think acknowledging or recognizing that if the court thinks that's not appropriate, then we will file within 4 days a civil complaint seeking the exact same relief. And simultaneously, Clark's attorney asked for a 4 day administrative stay, in other words, to extend the injunction. So I, I don't honestly see how the government can get out of this
No,
because,
she's got them coming and going. Because if you look at her
yep,
order, she put at the end of that electronic paperless minute order, or whatever we want to call it, that there were 3 motions that haven't been ruled on yet. And the first one is the defendant's original motion. She doesn't think she ruled on that. And so if that's right, then they can appeal, the government can appeal from her order, but they can challenge that order, but she can still issue an order on the original motion because she doesn't think she's ruled on it yet. You guys, are you following me? So they're chasing a red herring in the Court of Appeals, I think.
I didn't, I was going by my reading of her original order saying that she hadn't ruled on it. I did not catch that language. And I'm just looking real quick to see if that was, oh my gosh, Leslie, that's amazing. I did not catch that detail. So if you look at what Judge Cannon entered yesterday, she said the following motions remain pending and have not been ruled on. And then it expressly says the joint emergency motion as to the defendants. And here she then references the docket entry 679,
Yep.
which was the original motion
Yep.
that they asked for her to enter an injunction. So I was going based on my reading of what they asked for and my reading of what she had entered and said, no, she didn't rule on that. But Leslie, as you just pointed out, she said she didn't rule
Right.
on it.
She's telling
So,
them the docket number because that's the way the clerks and the courts keep track of all the motions is by the docket numbers.
Here's
um,
how she puts this all to rest tomorrow. She sets a briefing schedule that goes into February.
Right. Right.
well,
Because wait. What is the
she,
basis? What is the basis to take a district judge briefing schedule to the circuit?
None.
None. It's a
but,
matter of
That
managing
you
her own
cannot
docket.
appeal interlocutory.
She's
she
managing her
does,
docket.
she does have to enter an injunction though. But if she does as a TRO, that is not appealable either.
Right. Now, is that 11th Circuit precedent? Because I don't get that out of the statute that the government cannot appeal a TRO.
Well, the government said it in its briefing to the
They
11th
conceded,
Circuit.
but I'm wondering if that's 11th Circuit specific law. Chip, what do you think about that?
Uh,
No, I don't think so. I think there are I don't think you can take up a TRO. I mean,
yeah.
I have had judges accelerate the preliminary injunction
Right. Because you can appeal that.
because you can't appeal that. You know, you get a TRO for sometimes judges. I'll give you a TRO for 48 hours, but I want your briefing papers tomorrow, and the opponent has the following day, and we'll have a hearing 3 days from now. Because
Yeah.
typically a TRO can be put in place for 10 days, right, or 14 days, whatever.
I think it's 14, but in the Seventh Circuit, you couldn't appeal a TRO. And they only need 10 days, even if it is 10. But I think by statute it was 14. So Cannon does. I absolutely agree. She's going to set a briefing schedule, and she should. This isn't something that you just decide expeditiously because they don't like the fact that Trump got elected. This is
And
something
they're
that,
going to lose all power over all these
right.
decisions.
I mean,
That's the emergency.
right. This is a due process and a huge due process claim.
Right. Yeah.
And here, I think it's really important for people to recognize that Garland said basically, okay, we're not going to release volume 2 because it's not fair to these two defendants. But yet, volume 1 is not fair to Clark and a lot of other individuals in it
Right.
who are subject to legal jeopardy as well as having the whole lawfare against them in the bar
Right.
where they're trying to pull their licenses.
Right. Now, they're not directly in front of her, but and this is an argument, the one you just laid out that we talked about because King identified it early on, that it doesn't just affect Mr. Nauda and De Oliveira, or however you pronounce their names. I apologize for mangling them. It affects these other people in the Georgia case, in the Michigan case, in the Arizona case. Clark's lawyer points out in his briefing it affects Eastman also out in California. Now, they're not parties before the court. So, Margot, in the pleading we haven't seen yet that's not on the docket, but that you had a look at, Clark says he will file a separate suit if need be to put that properly in front of her, right?
Correct. And that I think would be the safest way to go if she does. But I think Cannon has enough in front of her for her to say I think Cannon will say, yeah, I can't listen to you. I can't consider your the impact on you unless you file a separate claim. But I think that Trump would likewise have a very strong interest in filing a separate claim because, as Clark's lawyers point out, they the special counsel did not dismiss the charges
With
related to
prejudice.
volume one
Mm.
with prejudice. So volume one will prejudice Trump as well as everybody else from a legal perspective, not merely from a reputational one, but from the perspective that he could be indicted in 4 years again.
And the
See,
government can't argue the opposite of that. They're the ones that said they wanted it to be without prejudice. Ship, what were you going to say?
I made this point the other night that he is going to be prejudiced in the DC jury pool.
Yeah.
They're going to hold this against him in 4 years. He will not get a fair trial in front of 12 DC jurors.
Right. In front of the oh so impartial bench and jury veneer in
No,
the
but
district.
to back up a minute, to be serious, I think Margot raises a very good point. At some point, Cannon is going to come back to that the balancing of interests here comes down to whether the Attorney General can publish this report that's the creature of a DOJ regulation that says nothing about publishing it. In fact, it calls it a confidential report versus the due process interests of these defendants in 3 other states, even
Right.
though they're not squarely before her.
Ah, but Clark raises a good point there, and Chip, I know you haven't read his brief. That there's this alleged coordination between the federal government and some of these
Good
others.
point. Exactly. I hadn't thought
Ah,
about that.
it's not like the DOJ can say, well, those state cases don't have anything to do with us.
All right. So there's a very real and substantive balancing of interests here. And I keep looking for, and I haven't read them that closely, so maybe they're in there. I keep looking for a meaningful description by DOJ as to the public interest or the irreparable harm in this not getting done by the 20th.
So, Ship, I think you might have missed it. It was footnote 7, and it said Orange Man bad.
Yeah. Did it have? Did it say Orange Man bad, or did it just have a picture of Trump's
That
mugshot?
was in Latin. We'll get to Latin here in a second.
But Margot, did it stop there? Because I assume
I,
Orange Bad will still be that on January 21st.
Right, there you go. That
So
survives.
so so the issue is, why is it urgent that the public be told for the 1,500th time Orange Man is bad?
Didn't
Obviously,
did,
they didn't get the message, King. They still voted for him.
didn't 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 Judge
77 million of us.
didn't Judge Chutkin publish the Orange Man bad volume?
Yes, right. We had that whole thing already. They dumped all this shit on the docket when um, Smith was trying to explain why there was no immunity problem in that case.
The other way Cannon could bury this, she could say, "Submit the report to me. I want to comb it for 6E material."
Well, I think that's a very strong argument that the defendants raise, that if nothing else, the district court has to be in control of, not the Department of Justice, what information reaches the jury veneer in her courthouse that might run afoul of the grand jury rules, right? How can you argue against that if you're the government? Now, one point that unfortunately, I listened to this podcast by Andrew Weissman and Mary McCord today. And so they raised a point. See what you guys think of this. They raised the point that since it is apparent to one and all that the Trump DOJ is almost certainly going to dismiss this case in the 11th Circuit after they take control, is there any real threat of prejudice to at least these two defendants? What do we think of this argument?
it it's hypothetically a good argument, but a judge can't act on that.
Right. Right.
Cannot.
That's the counter argument that, well, that
Mhm.
hasn't happened yet. So,
Well, that's why it doesn't make any sense that they haven't dismissed it already. What possible conceivable basis, other than to defend the appointment of a special counsel, what possible conceivable basis is there for DOJ to persist in the pursuit of Noda and De Oliveira?
right.
If they dismiss that, it takes a huge. It takes now who's filing the motions? Now you don't have any interested part, or you don't have any actual parties. You only have they would have to file a civil suit to stop it.
It even more than that. It they would have dismissed Trump and then dismissed the other two defendants from the appeal, which means they've abandoned the DOJ has abandoned the appeal, basically giving up on the issue that Jack Smith was properly appointed, which could affect their DC case
Yeah,
in the long.
though I understand your point, but I think they would look back and say, okay, well that means we've got one district court opinion that is binding on nobody,
Right.
and we've still got the DC appeals court that says appointing special counsels in this way is proper.
Proper.
I don't think they're really in fear of that because, as you know, one district judge is not binding on any other judges in their district, much less any judges anywhere else.
I think
Well,
one of the problems is that on the volume 2, that might get the attorney general basis to release it. On volume 1, you still have all the other people injured. But as Ship just suggested, or maybe it was King, the defendants, the two defendants, they could file a civil case immediately and seek a TRO to prevent the release of volume 2, arguing that the special counsel acted ultra vires they acted beyond their authority in doing this, and the release of the report injures us. We want an injunction to stop it. So even if they threw the case out at this point against those two, they could still stop it.
well, so let's talk for a minute about Merrick Garland's rationales here. Like has said publicly, he said in this letter to Congress, which may or may not have been a violation of her order. Looks to me like probably not, but not great either in the face of the fact that she had issued the order. But he's basically saying, I'm doing the same thing that every attorney general before me, including Bill Barr, did by releasing these special counsel reports on these, highly placed government officials, high public interest cases where we've had to appoint special counsel. And that's just how this rolls because the public interest and right to know these things kind of trumps all the other stuff. Of course, in almost all of those cases, there was no pending case. Weissman made the point on his podcast that in the Mueller case, there were still some pending pieces of litigation that they had spun off from their investigation to some of the U.S. attorney's
Yeah,
offices to pursue.
Concord Concord management was battering them about the head and neck until
Right,
they finally cried uncle and agreed to dismiss that case.
right.
But but
So
but Leslie, on the spun off cases, that final report did not get into the merits of those spun
that's
off.
the point he made too, is they redacted that out.
Right.
And that's one of the differences here, right? They want to release volume 1, which has to do with the J6 DC case. They're not going to redact all of that stuff, and so that it's not going to prejudice Eastman and the electors in Michigan and Arizona. I mean, they can't. That's what the whole volume is about. It would be blank pages after page after page after page.
And the 65 random people that Fonnie Willis decided to name as
Right.
defendants,
Yeah,
pulling
exactly.
names out of the phone book.
Right. So, you know,
And in Todd Blanche's letter to Garland, uh, objecting on many grounds to any release, uh, he didn't say much about what was in the final report, except that there in black and white in the middle of that letter, he says that report says basically there were conspiracy. There was a criminal conspiracy that Trump was ahead of, and that was the theme of the report.
Right, that he's basically guilty of without using
It
the word guilty, and all these other people helped him, so they're all guilty too.
correct, and so under Weissman's procedure, the report would be redacted before it's released.
Right. Yeah, right. So that doesn't make any sense. I do think Clark's lawyer did a good job of saying, hey, the attorney general has agreed not to release volume 2 because it would prejudice Nauta and de Oliveira in their defense. Why isn't that the same rationale for volume 1? Right? Like, even if those people aren't in front of the court, the government has conceded the point that releasing it does prejudice people who are mentioned in it. So, what could possibly be the government's argument for saying, but we want to release volume 1 anyway?
Margot quoted it a few minutes ago. It's in footnote 7.
The orange man bad. Okay. Right. All right. Let's turn for a second to this question that Clark and the defendants raise, that Cannon's ruling that Smith was improperly appointed under the appointments clause in the Constitution, that a logical extension of that point is that, oh, one of our cats has decided to join the discussion. So if you hear him, he's jumped up on the couch here. Um, that a logical extension of that argument is that Smith couldn't even finish the report and that Garland therefore also cannot publish it. What do you guys make of that argument?
I
Well,
like the argument that Smith has no authority as to Cannon's case, at least, and therefore it's not a special counsel's report. Can't be, because he's not a special counsel.
Yeah, I that was the same conclusion or thought I had, which was if if you in her court he's not properly appointed. That's law of the case, and on that basis, he doesn't fall under 600.01 through 15 or whatever those regulations CFR provisions are, and then that report referenced in there as a confidential report to the Attorney General, that's not what we're talking about. We're talking about an unauthorized version written by an extra constitutional actor.
Right. Now, Garland's response to that is he could have this report written by Mr. Nobody citizen in the street and receive it, and he, Garland, as the Attorney General, would still have authority to release it.
Not if he brings Mr. Nobody Citizen into the grand jury to hear the evidence. No, that he gets locked up if that happens.
No. Right. So, I mean, yes, but let's say we redacted out of Mr. Nobody's report any grand jury material.
I'm not talking about grand jury material. I'm talking about the grand jury evidence that the grand jury was presented, and by definition has to form a major part of the basis for any conclusions.
And if Jack Smith's signature is anywhere on it, according to Cannon's ruling, he was an unauthorized recipient of 6E material.
Oh, yeah, right,
Although,
right.
although you could argue that even if not a special counsel, his status would have reverted simply to a ordinary DOJ employee.
They make that argument too, that clearly Garland had the authority to simply hire him into the department, or he could have designated anyone in the department to do this work and said, these regs apply to you, Mr. AUSA from, Kansas. Uh, and that therefore Garland could release the report because it's not, has nothing to do with the improper appointment. But, the
There are some other regs and DOJ manuals that have other things to say about that,
right.
such as and legal lawyer ethics rules that basically say a prosecutor is his job is not to find somebody guilty in the public sphere. He tries his case to a jury, and the jury makes that decision.
Right. Now, we have
Until
sort
that
of
happens,
pretended with all these special counsel's reports and also with what Jim Comey did to Hillary Clinton, we have sort of pretended that these things are so important because they touch the highest ranking people in the nation, and therefore they're an exception to this principle that you just laid out. Do we think that that's right? Or is it just, King, as you and I were texting, it's kind of just political power? Right? We do this to the political people at the top, one party does to the other because we can.
you can't say that as to uh, all these alleged co-conspirators
Right.
who are being criminally charged in other places, and the two, what were they?
They were like
What?
Trump's helpers, assistants of some kind. Right.
Yeah, that that kind of stuff does not rise to the level of uh, uh, critical critical stuff that the
Right.
public has to
National
know.
interest. I agree. And that's the problem I have with Garland's position in his letter, which is he's acting like this is Starr's report about Bill, right? Or Mueller's report about Trump, or even Her's report about Biden, that really it's just about this very important, prominent person, the president of the United States. That's not what this report is about, though, principally. Right? Trump is the lead, but only, as Ship was just saying, or King, was it you, that only because he's the head of this conspiracy that all these other people are guilty of too, supposedly.
I think I posted about this today, but I think the rights of the accused, once an indictment has been returned, the due process rights, the right to confront witnesses, right to put on your defense through your own witnesses, uh, all of that trumps any national interest. And I think the big exception to that was the Ken Starr report, which I think uh, was the it created the whole problem in the first place that led to Congress deciding not to uh, uh, renew the Independent Counsel Act.
Right. Finally. Well, but so the logical corollary to that would be that Smith's report would never be released. Do we think that that makes sense?
Uh, a form of the report can be released, but in terms with the case not over, I don't think it can be.
Right. I lean toward that middle ground too, that as long as there are pending cases, it's not appropriate under due process principles to release it. As an historical document down the road, I think it can and should be released. But look, Margot, let's turn to the point you and I were debating earlier today, which is what about the status of these regulations? Right? One of the defense arguments, I think Jeff Clark might be making this argument too, or did you get this out of his amicus primarily, is that if Smith isn't properly appointed, then the regulations that say he's writing a report aren't any good either. That's way, way, way boiled down. But talk about that issue a little bit.
Right. So I I also think so. I think that's part of it, and the other part of it is you have to recognize that the special counsel report and the regulations came about after the statute authorizing an independent counsel were expired.
Right.
So what happened was they basically used regs to try to replicate what another statute had allowed. And that I think is where Clark's argument is, that there used to be a statute that gave the authority. That statute's not there. There was no authority to promulgate these regulations that allowed for the release of the report. So I think that is a good argument, because you have to look at what specific statute would authorize the DOJ to have the special counsel regs, and also look at the history of what happened here. And the history is that the independent counsel statute expired.
Right. And it was more specific. The authorities that the regs are relying on are the more general authorities that the federal agencies have. They're in the US Code. Congress has passed these that say agencies can write regs for their own internal housekeeping purposes, and that the head of a department, there's another statutory provision in Title 28, I think it is, that specifically says the AG can write regs for managing his department. And it includes things like releasing documents and so forth. So it's not like the Attorney General doesn't have authority to write these kinds of regs. It's like, yeah, but can they say what these say, given that the Constitution didn't allow you to create this officer?
And I would say, can you rely on those more general statutes to create this authority when the statute that had the specifics expired? So I think that those two factors together lead me to believe that no, there is no authority to write the report and release it. Maybe internally to have a report that is done by underlings, not a special counsel who is, in the grand jury, but by underlings. That would be a different matter. But the releasing part, I think, is the key difference too.
I think it's the same matter, even with an internally generated report that is issued in the middle, before the final end of a prosecution. Because it runs afoul of our Constitution.
Right.
Not
There's
only
a due
not only
process problem. Yeah.
is there no statutory grounds for that reg or for that practice, but it's unconstitutional. It's an unconstitutional violation of defendants or potential defendants' due process.
Well, it compounds it even more because you're therefore violating those people's rights using a document that purports to have the official imprimatur of the Department of Justice on it, when legally it's kind of a void document.
And,
I would
and, and I'll remind you that courts all over the country uh, regularly enforce legal ethics rules. And the uh, model code of ethics is crystal clear. The prosecutors can't do that.
Well, they're not supposed to. Let's put it that
They're prohibited from doing it. It's an
Right.
ethical.
The rule prohibits it. Yes. What were you going to say, Margo?
I was just going to note that the whole due process argument trumps or negates any need to ask whether the special counsel actually has that authority or not. So even if it was an internal report, it couldn't come out.
Right.
I think that Clark's um, team is also making the point that, look, there was no special counsel that was appropriately appointed, and they don't have any authority under these regs because the regs are not authorized by the statute. But those arguments you don't even really need to get to because of the point that King just made. You can't do this. When people are subject to legal jeopardy, you can't release this type of report against them.
Which the government here has conceded vis-a-vis these two defendants because they've agreed not to release volume 2, but they don't want to concede that vis-a-vis all the others.
Although, and Leslie, this is something I'm really keeping my eye on, is now that Clark's team has brought
Mhm.
this issue to the forefront.
Right.
Prior to this filing, and they did file at the 11th Circuit, but I actually had not seen it until the ruling. And obviously, the 11th Circuit did not grant the stay. But prior to this filing before Judge Cannon, it was really looking at, is it harming these two defendants?
Right.
Not, is volume 1 harming other people? Now Garland's folks know it. It's been brought to their attention.
Right.
Are they going to stand by and say, well, we don't care because they're not parties? Are they going to make that pedantic of
Right.
an
Exactly.
argument?
Right. The Department of Justice is going to say that. Okay. They might. They might. Another thing.
You
Go
know
ahead,
what?
Chip.
I actually think without the involvement of the special counsel's office and the lawyers from Public Integrity that were running this stuff for 3 years, they might not.
They might not. They might not
I
what?
think those
Be more clear about that.
those that they might not take that step and say we don't care about defendants in state cases. The programs branch might say, yeah, we're not going there.
Right. Actually, that's a good argument. We just didn't think of it before. That's what they said about volume 2 because they didn't think about it before. But you know what's really super fucking problematic about that? Why doesn't the Attorney General of the United States have that realization? He was a judge.
Who was stepped over at the
And
United
he's like,
States
yeah,
Supreme Court, and
Right.
he will never forget that.
Right. I mean, but it's just appallingly bad that the AG, who used to be a judge, doesn't see the argument that we still have people who have constitutional rights that this report implicates. This is not the situation that you had with these other reports, because it isn't. Go ahead, Shib.
that the department, all the lawyers in the Department of Justice are monolithic, and you usher 500 people out the door on the 19th, and you usher 500 new people in the door on the 20th, but these investigations have been driven by a small group of very partisan DOJ lawyers. And then
Right.
Jack Smith was brought in. I mean, Jay Britt. I mean, the whole crowd. They're all prominent Democrats. If you went back to the Mueller investigation, the same thing. Not counting
Right.
Mueller, no quite accounting for how he ended up there. But entire thing.
Ship, you're bouncing in and out. I can't understand a word you're saying. Try again.
Democrats. Well, I don't know. Now I'm wandering around my hotel room. Is it
That
helping?
you're clear now. Stay there.
Yeah. Okay. So the entire Mueller special counsel was staffed by partisan
Right.
Democrats. This special counsel was staffed by partisan Democrats. But, now you walk this case file down to the civil division programs branch. None of those people had anything to do with it. And now you want them to put their name on a piece of paper that says, we are of the position that the collateral consequences to defendants in state cases where we will in effect be calling them criminal conspirators in a publication of the Department of Justice. Nobody's
Screw
concerned
them
about
and their
that?
presumption of innocence. Right.
Right. I'm not sure they'll get that.
Right.
So what
We'll see.
happens then?
Garland can.
So what happens then if they come back with the same position on volume 1 as volume 2, which is we're only going to give it to the chair and the head Democrat of the Judiciary Committee? Will the judge let that go forward?
I don't know. I was going to say, what do we think the members of Congress, the Republican members of Congress, will think about this issue of protecting these other defendants by not branding them through the DOJ special counsels? Because normally the Congress would be clamoring for the report, saying we spent a fuck ton of the public's money on this, and so we think we're entitled to see what it is.
Well,
But
let's introduce this fact
yeah,
now. There's no longer a Democrat Senate Majority Leader.
right,
What stops the Senate Majority Leader, and what stops the Speaker from saying, "Nah, we're good."
right. From telling Garland in response to his letter, there's still pending cases. We don't want this. You hold on to it for a while.
Yeah, yeah. Just leave it on your desk. Somebody will come by
Somebody
and
will
get it.
pick it up next week. Oh God.
Put it put it in an envelope with my name on it. My name's Mike Johnson.
Right.
Actually, actually, that is a brilliant point that rather than make a public production about this and create any political backlash, they should, the leaders should send the letter that makes clear that the interests of Americans and the presumption of innocence has to trump our interests.
Right. Prevails at the moment. The public will have to wait a little
Yes.
longer. Yeah.
Yep,
Yeah.
exactly.
Yeah. So, well, I suppose we'll see if that happens. I may not hold my breath,
I don't know.
but that is
You
what
know,
should happen. And, what the
well,
right of center should think that's the right answer, I think.
and I think that now the Senate is an odd place,
Yeah.
but I think everybody is sort of the view right now that we crossed Donald Trump at our peril.
Yeah. Could be. I mean, and he obviously doesn't want the report released. Why would he?
Right.
Well, the way they structured the dismissal of the DC case, he still has jeopardy.
Right.
Got to protect those jurors.
Right. Right. Well, okay. So that's very interesting. The legislative angle is very different from what it normally is on these special counsel
Yeah. Hey,
issues.
I'm gonna have to bail
Yeah, I
here.
was going to
I'm gonna
tell
finish
people
going over my notes. Get
you've got
ready.
a closing argument in
Uh,
the morning, right?
yep. Well, we could work, but I've got 4 sentencings
Oh
this
my
week. I've got
God.
all kinds of stuff that I got to do after tomorrow.
Okay. All right. Well, you'll
So
be busy.
thanks everybody.
Thanks, Chip. Good night.
Check in later.
So I was going to tell folks that I think because Ship is very, very busy because the DC judges are trying to cram in as many of these J6 sentencings as they can before the administration changes hands, that King and I think, are going to try to cover a couple things. One of which is, King, did you see these tweets we got about why did the Trump guys not ask the Second Circuit to weigh in on that preemption issue?
I can't answer precisely why they didn't,
Right.
but I did conclude they probably had a heavy uphill
Heavy
b-
uphill battle. Right.
battle. Yeah,
Yeah. So
and
some people do seem to be interested in that, but I thought we would lay it out for folks one day this coming week while
yeah, that
Ship is busy.
yeah.
Yeah.
You want me to do it now or
No,
we'll?
no, no. Let's do that another night where we can give it its proper attention.
Okay.
So while we've been talking, I did look up the Latin, and so that footnote 7 should say "oronge homo malus."
Brilliant.
And, and just as to punctuate that, yes, we are all law nerds.
Right? You got to get your Latin in there. So the other thing I wanted to go over with people, Margot, have you been following this? Is the TikTok thing? Not tonight, but you
I,
won't be with us next time. So have you got any
yeah,
observations on that, real quick?
I don't. I haven't had a chance to read the argument. I wanted to see what the questions were, so that'll be fascinating. But I too also have to jump off, and
Yeah, I figured.
I
So
I, I figured that I won't do an Irish goodbye tonight. I'll
we
save it another
appreciate
time.
that. Thank you for
Thanks,
joining us,
everybody.
Margot.
Okay, bye bye.
Great. It's good talking to you. All right, King. So that just leaves us. You got any final words of wisdom?
I I remain standing on my soapbox that what they're trying to do to Trump and all of the other alleged co-conspirators is reprehensible.
It's wrong. Yeah, right.
It,
It's wrong. No matter how you slice it, no matter which analysis microscope we put it under, it's wrong, is the answer. Well, what's your prediction now that it's just down to the two of us? Will we get a ruling from Judge Cannon tomorrow?
I I don't have a prediction. This is too messed up. I would be stronger on that issue if we saw some of those others, state court defendants and Jeff Clark, actually file their intervention or file a separate suit
File a separate suit and
and
just
go for a
consolidate.
TRO.
Yeah.
That sort of highlights the issue. And that one, if she's convinced that there is prejudice, she's got to sign it.
Right. I'm not sure you can consolidate a civil case with a criminal case in the district court, so there's that. But if you have a related case under the circuit's rules,
Mhm.
it can be assigned to the same judge. So presumably Cannon would get that case if they file a civil case that's so closely related. But I'm wondering, King, do you think, given the fact that Judge Cannon doesn't seem to think that she's even ruled on the original motion, do you think she needs to rule by tomorrow because the other order that's up on appeal ends tomorrow or not?
Uh, One way or the other, she needs to extend that first order, either by entering a new order or s- some other way. But she's got the basic jurisdiction issue as to the existing order. It is on appeal.
Right. I don't think that's what she's going to do. I don't think she's going to extend that order. I think she's going to issue an order that says, this is my ruling on your original request. That other order that I issued was like an administrative stay, and the government is within its rights to appeal that, but that was not my order on the motion. So now here's your order on the motion.
I hope she does that, but whether she will, I'm not going to predict.
Yeah, based on her little paperless motion or order that she put on yesterday morning, I would bet good money that that's what she's going to do. So we'll see. All right. Well, on that note, I will say goodnight, and we will let you guys know when King will coordinate on when we want to talk about that Second Circuit issue, because the Volk conspiracy guys wrote an article about it.
Can't wait.
Yep. All right. Good night, all.
Good night.